Greetings. My name is Erin Carlson Mast, and it is my pleasure to serve as the CEO of President Lincoln's Cottage and to welcome you to our 5th annual Lincoln Ideas Forum. I hope you'll also join us at the conclusion of the talk for book signings with 2 of today's speakers downstairs. Please also silence your cell phones at this time if you have not already. In the forum today, we explore the intersection of President Lincoln's life and legacy with contemporary issues we face. Since its inception, this program was intentionally placed in mid-April to mark the anniversaries of Lincoln's last visit to the Cottage on the 13th, his assassination, and DC Emancipation Day on April 16th. Our goal with this program each year is to commemorate ideas Lincoln nurtured into action while living here, as well as to highlight the unfinished work. This year, we've partnered with the Constitutional Sources Project to discuss the important issue of voting rights. It is my pleasure to introduce the director of ConSource, Julie Silverbrook. Julie Silverbrook is executive director of the Constitutional Sources Project, a nonpartisan, nonprofit organization. ConSource is devoted to increasing understanding, facilitating research, and encouraging discussions of the U.S. Constitution by connecting individuals with the documentary history of its creation, ratification, and amendment. ConSource educates lawyers, judges, teachers, and students about United States constitutional history. Prior to leading ConSource, Ms. Silverbrook was the founding director of an award-winning constitutional literacy program called Constitutional Conversations, in collaboration with the Institute of Bill of Rights Law at William and Mary Law School, the Colonial Williamsburg Foundation, and the Williamsburg Regional Library System. Ms. Silverbrook holds a JD from the William and Mary Law School, where she received the National Association of Women Lawyers Award and the Thurgood Marshall Award, and served as a senior articles editor of the William and Mary Bill of Rights Journal. She graduated summa cum laude, Phi Beta Kappa, from the George Washington University with a BA in political science. Please join me in welcoming Julie Silverbrook.
So, Erin, again, thank you. That was a very, very generous, embarrassingly generous introduction. We're so pleased to partner with President Lincoln's Cottage. I discovered this hidden gem in DC a couple of years ago because I didn't have plans for New Year's Eve, and I saw online that President Lincoln's Cottage was hosting a New Year's Eve party because of at midnight it becomes January 1, which is when the Emancipation Proclamation went into effect. I believe the Emancipation Proclamation was drafted in part here at Lincoln's Cottage. So because I had nothing to do and I love everything about American history and the Constitution, I was able to rope some friends into coming with me and came and just fell in love with this place. And that's when I started thinking about how can we work with President Lincoln's Cottage to do some programming on constitutional issues that are relevant to people today. So I connected with Callie in the back, and we came up with the idea of voting rights. And I think this is so significant because I truly believe that our country is in the midst of a great civics awakening. I run an organization that focuses on civic education and constitutional literacy, and I can tell you every single day we get lots of traffic to our website, significantly more than we have in past years, emails, etc., all asking questions about the Constitution and its relationship to things that are happening within our government. People who have previously not been civically engaged are becoming civically engaged for the first time in their lives. There are efforts to improve civic education within our schools, and there are programs like this one that are efforts to reach the general population. So I'm really thrilled to partner with President Lincoln's Cottage to bring both the Cottage, its relationship to Lincoln, and its relationship between Lincoln and Washington, D.C., and Lincoln and the broader world into the spotlight through this program. As I mentioned, the topic of today's forum is voting rights, and I can never do a talk without using some really good quotes from other people. So Ronald Reagan famously called the right to vote the crown jewel of American liberties. When the 15th Amendment was ratified in 1870, President Ulysses S. Grant sent a special message to Congress. In that message, he shared that the adoption of the 15th Amendment to the Constitution completes the greatest civil change and constitutes the most important event that has occurred since the nation came into life in 1776. Susan B. Anthony once said that in the very first paragraph of the Declaration of Independence is the assertion of the natural right of all to the ballot. For how can the consent of the governed be given if the right to vote be denied? I'm looking forward to hearing from our speakers today about the history of voting rights in our nation and some of the contemporary issues and challenges that confront us, especially as we approach what is sure to be a contentious presidential election next year. So with that, I'm going to turn it back over to Erin, who will introduce our fabulous moderator and formally kick off today's forum.
All right. Thank you, Julie. This year's Lincoln Ideas Forum brings together experts, scholars, and the public in an exploration of the historic context of citizenship, voting rights, and the Constitution, alongside the contemporary repercussions of debates over who gets elective franchise. Lincoln believed in the experiment of American democracy, which was still relatively new when he took office in 1861. He considered elections the bedrock of the republic and that an engaged citizenry deserved to have their voices heard. At the start of the Civil War, he argued before an emergency session of Congress, quote, that ballots are the rightful and peaceful successors of bullets, and that when ballots have fairly and constitutionally decided, there could be no successful appeal back to bullets. This mantra of the ballot is stronger than the bullet appeared again and again throughout his writing and speeches. Throughout his career, he defended immigrants' right to vote, and towards the end of his life, he did endorse voting rights for formerly enslaved men, an idea Booth is said to have said would be his last. Lincoln would not live to see the 15th Amendment. President Lincoln's Cottage is, we also feel, an ideal place to be discussing this fundamental civil right, voting rights, and how it has shaped our nation. This Tuesday marks the 157th anniversary of the D.C. Emancipation Act, a plan for compensated emancipation which Congress passed in 1862. Lincoln wanted to use that as a template in a way for his proclamation, which he began working on that very summer here at the Cottage. DC emancipation came first in part because Congress had control of the city, and the majority of congressmen who would have been opposed to the DC Emancipation Act were absent because they had seceded. So they weren't present to object. However beneficial that arrangement was in that moment of time, of course, that same arrangement has also been the source of great debate as DC residents call for full representation in government since the city's founding. It is now my pleasure to introduce our moderator, Lillian Cunningham. Lillian Cunningham is a journalist at the Washington Post. She is the creator and host of the Post's presidential and constitutional podcasts. Presidential was a 2017 Webby Award honoree for Best Documentary Podcast and a finalist for the Academy of Podcasters' Best News and Politics Podcast. Previously, Lillian was the editor of the Post's On Leadership section and won 2 Emmy Awards for her video interview series with leaders across politics, business, and the arts. Please join me in welcoming Lillian Cunningham.
Thank you so much, Erin, and good afternoon, everyone. It's so nice to be here moderating this event. I got to know Erin through the work that I did on the presidential podcast, and I got to know Julie Silverbrook through the work that I did afterward on the constitutional podcast. So it feels just like a real honor and pleasure to be asked to moderate an event that their institutions are co-hosting. And I thought I would just mention that I did both of those podcasts for the Post, not because I was an expert on either subject. It was actually the opposite, that I had this desire to learn more about American history, to learn more about the presidency, the Constitution, and to feel better informed about the way that history sort of shaped the country as we understand it today. And I imagine that's what brings a lot of you here. You take time off out of your day on a Friday to come and be part of this event. And I know it shows a commitment to your own self-education and to that spirit of constantly all becoming better informed citizens. So it's fantastic to see you all here. You know, and when Erin and Julie first asked me to moderate this event, I thought, you know, oh, what an amazing coincidence it is that there are these two incredible experts I know from these two different projects I did, and that they happen to know each other and work on something together. But of course, it's not really a coincidence. It's, you know, it's proof of just the really important ways in which our presidential story and our constitutional story are constantly intersecting with each other, and, you know, today are still constantly in conversation with each other, which is why reflecting on the work that Lincoln did here at the Cottage is so important, to strengthen the Constitution and save the Union. But also, you know, as Julie mentioned, why it's so important as we kind of sit on the verge of another presidential election cycle 150 plus years later, to ask ourselves, you know, what work is it that still remains to be done to move us toward a more perfect union? And so our event today is going to, you know, try to be part of helping us engage in an answer to that question. And we have four really great experts who are going to share their knowledge with us. And the first one, which I'll introduce more fully in a minute, is Jason Torchinsky, who's going to talk about the impact that changes in campaign finance and redistricting have had on voting rights. Then we'll hear from Brianne Gorod on voter suppression, then from Robert Tsai on the First Amendment's role in protecting the right to vote. And then finally, we'll hear from Elaine Weis, who's going to talk about this idea of the women's vote. So just, you know, the way this is going to work is, you know, I'll give an extended bio before each speaker comes up. And at the end of this, we'll do sort of a wrap up where we try to tie a bunch of the themes from everyone's discussions together. And the original idea was that I would try to tie all of that together, but instead, what we thought would be great is to just make this a bit more participatory. And so I think all of you got index cards and pens when you came in. And we would love to get the benefit of all the thoughtful people who are in this room. So as speakers are up here and it sparks an idea for you about, you know, a question that as a nation we need to be asking ourselves, or just an observation that really hits home for you that they make, just jot it down. And during the little breaks as new speakers get up, there's some staff who will come around and just collect those cards, and they'll pass them along to me. And then at the end, I'll try to sort of read through people's remarks and questions and try to help us all kind of not just leave with our own thoughts about what we've heard, but with some insight into what our neighbors have taken away from the conversation as well. So we will kick off the first discussion with Jason Torchinsky, which is a little switch from your program. But Jason is a partner at Holtzman, Vogel, Josifiak, Torchinsky. And in addition to his practice counseling clients on compliance with campaign finance, ethics laws, lobbying disclosure, and election laws, Jason has also served as lead counsel in a number of litigation matters dealing with First Amendment freedoms and with election law and redistricting issues. He's filed numerous amicus briefs with the US Supreme Court, including one on behalf of the NRSC and NRCC that was cited in the court's opinion in McCutcheon v. Federal Election Commission. Jason has represented candidates across the country during post-election canvass and recount processes, and he also serves as an adjunct professor at the College of William and Mary Law School, where he teaches about the IRS and political campaigns. Before joining the firm, Jason was counsel to the Assistant Attorney General for the Civil Rights Division at the US Department of Justice, And during the 2004 election cycle, he served as Deputy General Counsel to Bush Cheney 04 and as Deputy General Counsel to the 2005 Presidential Inaugural Committee. He's been recognized by Chambers USA as one of the top government law attorneys in the country. He's been honored by Politico as one of the 50 politicos to watch. And he's also been named a rising star of politics by Campaigns and Election magazine. So join me in welcoming Jason.
Well, thanks everybody. It's great to be here at the Lincoln Cottage, and since I'm going to talk about political parties, it's even more fitting that, we're here at the Lincoln Cottage. I want to talk about some of the reforms that we've seen over the last couple of years and last couple of decades, and the impact that these reforms have had on political party institutional loyalty and sort of my personal view on what I think that's done to our politics overall. In case it won't surprise you, I'm a little bit of an institutionalist, and I think that political parties as institutions have played basically a positive role in our politics over the decades. And I think some of the reforms that have been advocated over the last 20 or 30 years have really challenged the positions that political parties have historically held and really made it harder for the political parties to function in a lot of what was otherwise or historically their kind of centering role in our political institutions. A lot of the reforms that I'm going to talk about are ones we've seen proposed since 2000, and I think it has really driven both sides on the right and the left to extremes. I also want to point out that Congress and state legislatures very rarely pass political reforms that aren't carved up by the courts. In fact, because they keep running into the First Amendment every time they try to regulate in this area. I want to go back and just think about the federal election law, which is what I'm going to focus most of my campaign finance discussion on. When Congress, back in the mid-'70s, when Congress initially passed the sort of post-Watergate campaign finance law, there were sort of two pieces of it. There was the regulation of expenditures and there was the regulation of contributions. Well, the Supreme Court struck down all of the regulation of expenditures, but said, okay, we're going to let you limit contributions. I'm not sure whether Congress would have passed FECA if they knew the Supreme Court was going to strike down half the law. But the Supreme Court did strike down half the law, and so for a long period of time, from the time the Supreme Court struck down the sort of restrictions on expenditures and allowed the restrictions on the contributions, there really was a period of stability from about 1976 to about 1996. There were political party contribution limits, there were limits to candidates, there was what we refer to today as soft money, which people think was an undisclosed sort of pot of money. It wasn't. It was actually disclosed. It was unlimited, but it was disclosed and it was used nationally and in states for some specific purposes. And generally from the mid-'70s through the mid-'90s, you saw really strong political party organizations. And what do I mean when I say there were strong political party organizations? If you wanted to run for office and sort of work your way up from, school board to running for president, there was a system in place. You would serve on your county commission. You would serve as a local mayor. You would get elected to your state house, and then maybe you'd get elected to your state senate. And then maybe you'd think about running for Congress, and maybe you'd serve in Congress for a couple of years, and then maybe you'd think about running for president, after you had served in one or more of these executive positions. Or similarly, some people followed the governor track, where you served in the legislature, and then maybe you served as a state cabinet official, and then maybe you ran for governor. And the political parties really, for about 2 decades, or almost 3 decades, had a lot of say in sort of who advanced through that process and through that system. And then you got to the late 90s, and just to go back to what was happening in the late 90s, we haven't had this in a good number of years, but presidential campaigns used to be entirely publicly financed, or at least in large part publicly financed. In the political party primaries, there was a matching funds program where as candidates raised money, the federal government would match certain amounts of it. In exchange for this federal government, and this only applied to presidential campaigns, in exchange for this matching, what would happen is, because the government was giving you money on the contribution side, they could actually, because this was a matching program, limit you on the expenditure side. And presidential candidates were very limited in what they could spend per state. So for example, for both parties, Iowa and New Hampshire have always been critical early states. Well, guess what? They also are states with really small populations, and the spending formula was based on the population of the states. So you would see lots of expenditures from both parties in Massachusetts. Why are you seeing expenditures from candidates in both parties in Massachusetts? Because the Boston media market reaches into like 2/3 of New Hampshire. So you would see candidates playing with these sort of primary expenditures and their state allocations. They would spend in like the Illinois markets that reached over the border into Iowa. And there were all kinds of shenanigans that the candidates on both sides did to try to deal with this public financing. Well, what happened in 1996 was both Bob Dole and Bill Clinton ran out of money. They were up against their expenditure limits for the primaries, and their conventions were approaching, and they didn't get their general election grant dollars until they actually got to the day after their conventions closed. That's when the Treasury would literally wire them, tens of millions of dollars for them to conduct their fall campaign. Just as an aside, if you notice, when we had public financing of presidential campaigns, the conventions kept getting later and later, and now they're back way earlier. It's all driven by campaign finance. So what happened in 1996 when both sides ran out of money, the RNC and the DNC went to the Federal Election Commission jointly and said, hey, can we spend money, this soft money that we have, can we spend this on issue ads? And the FEC said, sure, go ahead. And so what happened was you had about 4 years where the political parties were now spending money on, both sides were spending money on issue ads. And by the time the 2000 campaign got around, there were a lot of outside groups that were now spending money on issue ads. And in particular, one that bothered Senator McCain was a group out of that aired an advertisement in South Carolina. It was called Republicans for Clean Air. Two brothers, it turned out, were actually the funders behind that ad, and their names were, no kidding, their last name was Wiley. So the Wiley brothers were the funders behind Republicans for Clean Air. They subsequently, for unrelated reasons to campaign finance, went to jail for fraud in the campaign finance world, in the securities finance world. But the attacks that the Wiley brothers funded on John McCain really set him on a path to reforming campaign finance law. And that came to fruition in 2002. And what did BICRA do, in my view? I think that BICRA really hurt the political parties as institutions. It eliminated the national party committee's access to soft money, which I know a lot of people think is bad, but on the other hand, it was also a resource that they had that they were cut off from. It allowed the political parties themselves to engage in issue advocacy. It made fundraising harder for state party committees. And when you make fundraising harder for state party committees, you also change the quality and character of people that run for state party leadership positions. When it was easier to raise money as a state party chairman, if you look back at the 70s, 80s, 90s, there were really powerful state party chairmen on the Republican and Democratic sides who really played a big role in who ran for office, what they said when they ran for office, what they did when they got to whatever legislative body they were part of, or what they did when they were executives. And when BICRA really essentially strangled the political party financing structure, it became a lot harder to get sort of strong, powerful people to run for those offices because their control of resources was dramatically weakened. And I think this also led to, at least on both the Republican and Democratic sides, it's state party leadership that makes up their national committees. So you used to have a whole lot of really strong people on both sides that ultimately made up their national party committees. Well, when campaign finance reform weakened the state party structures, because it cut them off from financing, it also weakened the national party structures. And going back to the old quote from the Supreme Court, money like water will find a way. Well, guess what it did. And in 2004, we had, when I was deputy counsel for President Bush's reelection campaign, we had the rise of what were termed unincorporated associations on both sides. These were the 527s from 2004. And on the left, you had an entity called the Media Fund, and on the right, you had Swift Boat Veterans for Truth. Both of them disclosed who their donors were, disclosed where their money came from, but they didn't disclose it on a particularly timely basis. But here's where I think that groups like this start to hurt it really cut in on the role that the RNC and the DNC have, and the other political parties have historically played. I think that the Media Fund said things about President Bush, and Swift Boat Veterans for Truth said things about John Kerry that the DNC or the RNC never would have said about their opponent. And the reason is the RNC and the DNC have had long-term interests in trying to get at least a plurality of voters supporting their ideas and their views and their candidates for the long term. And the problem is when campaign finance reform drove the money away from the political parties, I think it really drove money to groups that literally don't care about the long term. The Swift Boat Veterans for Truth had one goal in mind, and that was to prevent John Kerry from being president. The Media Fund existed for one election cycle, and its whole job was to stop George W. Bush from being reelected. And you've seen that play out, and I want to go through kind of how campaign finance has done this. The reason we had these unincorporated associations was Congress passed, as part of BICRA, something called an electioneering communications rule. And the electioneering communications rule, initially it was a ban, and it said within 30 days of a primary or 60 days of a general, no incorporated association, labor union, or bank could put up a broadcast ad that mentioned or referred to a candidate for federal office that aired within their electorate. In 2007, the Supreme Court said, you can't really ban that speech because there's a lot of actual legislative activity that goes on in the 30 days before primaries and 60 days before generals, and so you can't ban all that speech, but you can ban it if it's not true grassroots lobbying. And the Supreme Court didn't really explain what they meant, but that's what led to the FEC then enacting, this is in 2007, 2008 time period, what the Supreme Court later described as a 3-part 11-factor test to help speakers decide whether or not they could air ads during these 30 and 60-day periods. And believe it or not, that's actually what led to Citizens United. It was this electioneering communications ban and then led to the Supreme Court's decision in Citizens United. And I want to talk a little bit about Citizens United because it's one of the worst reported cases in the media about what it actually was. It started out as like a sleepy thing that only campaign finance lawyers like me paid any attention to. And the question was, this group had done this documentary about Hillary Clinton, and it said a lot of unfavorable things about Hillary Clinton, but it never said don't vote against her. If you watched it, you could certainly walk away from the movie with the idea that you shouldn't vote for Hillary Clinton, but they never said don't vote for or against her. And this group wanted to literally put this movie in movie theaters and on pay-per-view on cable, and they wanted to know about their advertising. And so literally campaign finance lawyers like me really thought that this whole case was going to turn on whether or not pay-per-view was broadcast. Like that's what we thought this case was going for. And then when we got to the oral argument, the government didn't do so well either time. The first time when the government sort of started asking questions of the Deputy Solicitor General who was arguing, and the case was, by the way, argued twice. So I'm going to tell the story of both times. The first time the case was argued, the court started asking the Deputy Solicitor General, well, under this electioneering communications ban theory, could the government ban a publisher from publishing a book that contained a single sentence of express advocacy? And the Deputy Solicitor General said, of course, Your Honor, yes, we could. And like, have you all seen the movie Ghostbusters? Remember the scene where the one Ghostbuster looks at the other Ghostbuster and says, if anyone ever asks you if you're a god, say yes? Well, if an American judge ever asks you if the government can ban a book, your answer should be no, right? But apparently the Deputy Solicitor General hadn't gotten that message. So fast forward to June of 2009 or 2010, and the Supreme Court, June of 2009, the Supreme Court actually set the case for re-argument, right? Everybody expects Supreme Court cases to be heard in June. This one didn't get decided in June. It got put off to September. Now we have Elena Kagan, who's now Justice Kagan, as the Solicitor General, and she's arguing the case. And she gets up and Justice Ginsburg says to her, so has the government rethought its position about banning books? And she says, well, yes, we have. And in fact, we think it would be a really bad idea. And then one of the other justices says, well, what about a pamphlet? And she says, well, certainly we could ban a pamphlet. And then one of the justices says, well, is a 17-page document a pamphlet or a book? And she was like, it did not go well from there. And that led to the Supreme Court essentially saying, look, the government can't stop people who otherwise have an individual right to speak from pooling their assets and their resources and speaking. And what that meant was once again, that decision ultimately strengthened the ability of these outside groups to speak and weaken the ability of political parties, because now the RNC and the DNC are stuck with the hard dollar limits. but a group on the right and a group on the left can go to a number of wealthy people and collect 6- and 7-figure checks and put that money into a pot and advertise with it. And the political parties literally are legally not allowed to have any control over what those outside groups do. And so what do you wind up having on the left? You wind up having, whether on the left you see a lot of pro-life groups, right-to-life groups, pro-abortion groups. On the right, you see a lot of gun rights groups and pro-life groups. And so what do you see? You see this money driving the electorate far to the right or far to the left, which is not necessarily where the electorate would be driven if the RNC and the DNC were controlling these resources. And so, and I know that I'm getting close to the end of my time, but what you saw on the right is you saw the rise of the Tea Party and the Freedom Caucus in 2010 that resulted right after Citizens United. And now on the left, you've seen the rise of democratic socialists, also supported by super PACs and small dollar donations on the left. So once again, the parties are still weakened. The Supreme Court tried a little bit in 2014. There was a decision called McCutcheon v. FEC, where I wrote one of the briefs. But in McCutcheon, there was also, in addition to the individual limits you could give to parties for wealthier donors, there was a 2 calendar year limit on how much they could give. And the Supreme Court struck that down and said, no, because you used to only be able to literally max out to 8 candidates in a 2-year cycle. And the Supreme Court basically said, well, if 8 is not corrupting, what's corrupting about a maxed out contribution to the 9th? And the government basically had no answer for that. So once again, something that Congress passed, the Supreme Court struck down. So what we have is a situation now where the political parties on the campaign finance side are weakened, the outside groups are on the right and the left are strengthened, and the political parties are marginalized. And then you get to, let's call it the last couple of years, particularly since the 2010 redistricting round, and you see these groups, these same reform groups that were pushing campaign finance reform, now decided campaign finance didn't fix politics, so now they're on to redistricting reform to fix politics. But what are they doing? A lot of this drive now is towards these independent commissions. And I think one of the problems with the independent commissions is it is once again weakening the political party institutional structures. When party leadership on both sides controlled what their districts looked like and what the maps of the districts looked like, it played a role in helping to control, who got elected from different parts of various states. And instead, now now the reformers have weakened the political party structure on the campaign finance side, and now they're going into the legislative structures of the state and even further weakening the political party leadership, because they're pushing these things to so-called independent commissions. And the independent commissions are interesting. They're independent in the sense that they have some combination of Republicans and Democrats, but if you really look into what they're doing, most of those commissions require that the people that are holding the Republican or Democratic seats on the commissions not have been politically active any time in recent memory. In some states it's 6 years, in some states it's 10 years, and so what are you doing? You're shifting where the politics of redistricting happens from legislative leadership who have interest in long-term caucuses that support their views to the staff of these independent commissions who may have one view or another but are not politically accountable at all. And so a marginal member who was like, I don't really want to vote for what the leadership is telling me to, now the leadership can't even go to them and say, we're moving your grandmother's house to the next district if you don't vote this way. The political leadership can't do that anymore. Now it's, you like the guys in that precinct? All right, I can't do anything about it. So once again, these reforms are weakening the tools that party leadership used to use to sort of control politics and the caucuses and the compositions of these legislative bodies. So, when you look at the history of these reforms, I think these reforms are making the control of these institutions a little harder. And again, I get back to the idea that I think political parties have historically had a real centering effect on politics, and both the campaign finance reforms and the redistricting reforms are making that a lot harder. I guess my view is if we had stronger political parties with more resources and stronger institutional leadership in the political parties and in the legislative bodies, it would be a good thing. But I think you really need to pay attention as you watch how these reforms, both on the campaign finance side and the redistricting side, I think make it harder to have a more centered view of politics, and these reforms in a lot of ways are really strengthening the extremes on both sides.
Thank you. It was wonderful and very bleak. So we will, while I introduce the next speaker, if that left you with thoughts or questions, please, jot them down, and that way they can become part of our discussion later. But next up is Brianne Gorod, who's getting ready. Brianne is the Chief Counsel at the Constitutional Accountability Center, where she previously served as the center's appellate counsel. She joined the Constitutional Accountability Center from private practice at O'Melveny and Myers, where she was counsel in the firm's Supreme Court and appellate practice. Before that, from 2009 to 2011, she was an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice. She has served as a law clerk for Justice Stephen Breyer on the U.S. Supreme Court, a law clerk for Judge Robert A. Katzman on the U.S. Court of Appeals for the Second Circuit, and as a law clerk for Judge Jed Ratkov on the U.S. District Court for the Southern District of New York. Her academic writings have appeared in a ton of places, including Yale Law Journal, the Duke Law Journal, the Northwestern University Law Review, the Washington Law Review, NYU Journal of Law. And her writing has also appeared in outlets like the Washington Post, the LA Times, Slate, the New Republic, SCOTUS Blog, CNN, Reuters. So it's wonderful to have you, and let's just all give a warm welcome to Brianne. Thank you.
Thank you, Lillian, and thank you to President Lincoln's Cottage and to Constitutional Sources Project for inviting me to participate in this year's Lincoln Ideas Forum. I'm so excited to be here to talk about and to listen to others talk about the issues of voting rights and voter suppression, because these are really among the most important topics that our country faces today. The right to vote is fundamental. As the Supreme Court has observed, this right to vote, this fundamental right, is preservative of other rights, both basic civil and political rights. And so in thinking about this topic, about voting rights and voter suppression, I want to start with the Constitution. I want to start with its text and its history and its values, because the Constitution provides an incredibly important backdrop to understanding the issue, to thinking about both voting rights and voter suppression, to thinking about what problems we face, and just as importantly, thinking about how we can begin to address those problems. When our Constitution's framers drafted our national charter more than 2 centuries ago, they recognized that the true principle of a republic is that the people should choose whom they please to govern them. Indeed, no right is protected by more parts of the Constitution than is the right to vote. As Justice Ruth Bader Ginsburg has observed, the words right to vote, those 3 simple words, appear in 5 separate places in the Constitution. All of which is to say, the Constitution's commitment to the right to vote, the Constitution's commitment to fair and free elections is deep and it's pervasive. And so I want to spend some of my time this afternoon focusing in particular on 2 constitutional provisions, both of which underscore Congress's significant power to enact measures that protect the right to vote. So the first of these is the Elections Clause. So this is the clause in the Constitution that provides that, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but, and this is the important but for our purposes, the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. So the plain text of the Elections Clause confers on states the power to regulate elections for federal representatives, a power they didn't have before the Constitution was adopted, but then gives the federal government, gives the Congress, the power to make or alter those resulting state laws. And where Congress decides to invoke this power to make or alter state election law, Congress's chosen regulation supersedes, it overrides these state rules. So that's an incredible power that the framers gave to Congress to supersede, to override state election rules. And the framers didn't do this lightly. This was a time in which there was a very strong belief in the sovereignty of the states and in state power, but the framers gave this power to Congress because they viewed federal elections and the regulation of federal elections as so important that they thought it imperative that the central government, that Congress, have this power. Law professor Fernita Tolson has written about the Elections Clause and noted the importance of elections was a recurrent theme during the convention. So Congress's ability to veto state electoral regulations was widely seen as necessary to prevent the states from destroying the national government. And so our Constitution's framers included the Elections Clause in the Constitution because they concluded the federal government must have the final say over the mechanics of federal elections. As the Supreme Court has recognized, the Elections Clause was, quote, this is the Supreme Court's words, the framers' insurance against the possibility that a state would refuse to provide for election of representatives to the federal Congress, and it provides a safeguard against manipulation of electoral rules by politicians and factions in the states to entrench themselves or place their interests over that of the electorate. Now, at the founding, this breadth of Congress's express power to make or alter state regulation of federal elections was understood by supporters and detractors alike. You know, people may have liked it, they may not have liked it, but everyone agreed that Congress was being given an incredibly broad power. The plain text of the Elections Clause, James Madison argued at the Constitutional Convention, uses, he said, words of great latitude, recognizing that it was impossible to foresee all the abuses that might be made of the state's discretionary power. And Madison was particularly concerned that the states would use their power to regulate elections to skew the outcomes of federal elections. He said, whenever the state legislature had a favorable measure to carry, they would take care to mold their regulations so as to favor the candidates that they wished to succeed. And so by the close of debates at the convention, there was an overwhelming consensus that the Constitution needed to give this power to the Congress. As one said at the conventions, there was a need to give the national legislature a power to alter the provisions of the states, but also to make regulation in case the states should fail or refuse altogether. And as the Constitution moved to the states and to ratifying conventions, again, the Constitution supporters justified this congressional control over elections as, and Pauline Maier has put it, a way of correcting unjust state voting systems and defending the people's right to equal voting power. So in the Virginia ratifying convention, for example, James Madison is again talking about the importance of this clause, and he stressed the importance of the federal role in securing equal voting rights. Should the people of any state, he said, by any means be deprived of the right of suffrage, it was judged proper that it should be remedied by the general government. Likewise, in the Massachusetts Convention, Federalists argued that the Elections Clause was necessary both for preserving the Union and securing to people their equal rights of elections. And in the first Congress, the framers once again affirmed the need for strong federal power to protect the right to vote in federal elections from denial or abridgment by the states. So during debates over proposed amendments to the Constitution, there was actually a proposal to claw back some of the power that Congress had been given in the Elections Clause, and the framers expressly rejected that amendment. And so what does this all mean? Well, the framers' understanding was that Congress would have the final say over questions of balloting, location of polling places, districting, and other of, as the Supreme Court has put it, the numerous requirements as to procedure and safeguards, which experience shows are necessary in order to protect the fundamental right involved. And what this means is that Congress can use its Elections Clause authority to regulate nearly every facet of federal electoral process, from voter registration to the counting of ballots. So that's the Elections Clause. And the other provision that I want to talk about for just a few minutes is the 15th Amendment. The 15th Amendment, which was obviously passed in the wake of our nation's Civil War, which you've already heard a little bit about from Julie this morning or this afternoon. This is the amendment that provides that, quote, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of their race, color, or previous condition of servitude. As the Supreme Court has observed, its language is as simple in command as it is comprehensive in reach. And in writing the 15th Amendment, the framers expressly invested Congress, again, Congress, with a central role in protecting the right to vote against all forms of racial discrimination by providing in the text of the amendment itself that the Congress shall have power to enforce this article by appropriate legislation. By adding this language, the framers indicated that Congress was to be chiefly responsible for implementing the rights created by the amendment, and that Congress would have, and these are the Supreme Court's words, full remedial powers to effectuate the constitutional prohibition against racial discrimination in voting. In other words, the framers gave to Congress a broad affirmative power to secure the right to vote. And they did this for a real reason. They feared that without a broad enforcement power, the constitutional guarantee would not be fully realized. As one of the framers of the 15th Amendment said during debates about it, who is to stand as the champion of the individual and enforce the guarantee of the Constitution in his behalf as against the so-called sovereignty of the states? Clearly, no power but that of the central government. Indeed, the framers of the 15th Amendment recognized that a broad legislative power to protect the right to vote against all forms of racial discrimination, both subtle and heavy-handed, was critical. So during debates over the 15th Amendment, the framers observed that it is difficult, by any language, to provide against every imaginary wrong or evil which may arise in the administration of the laws of suffrage in the several states. And they emphasized, what they desired to reach was to ensure by constitutional enactment the right of suffrage of citizens without regard to race. In the months following the ratification of the 15th Amendment, Congress recognized the grim reality that many states would pursue novel methods of disenfranchising African Americans on account of their race. And so, highlighting the importance of providing proper machinery for enforcing the 15th Amendment, Senator William Stewart at the time explained that it is impossible to enumerate over specifically all the requirements that might be made as prerequisites for voting. The states can invent, he said, just as many requirements for voting as you have fingers and toes. They could make one every day. And so the only means to ensure minority voting rights, the framers believed, was to be found in national legislation. And so what's the upshot here? Well, again, what we see is an investment of extraordinary power in Congress. The 15th Amendment empowers Congress to enact prophylactic legislation designed to guard against evils that have not yet arisen, but that may arise in the future. And second, as both supporters and opponents of the 15th Amendment recognized at the time of its passage, the 15th Amendment's enforcement clause significantly altered the balance of power between the federal government and the states. Senator Carl Schurz at the time, during debates over Congress's first attempt to enforce the 15th Amendment, said, "The Constitution of the United States has been changed in some most essential points. That change does amount to a great revolution." All of which is to say, it is impossible, I think, to overstate the significance of the 15th Amendment. Impossible to overstate its transformative power in reshaping the relationship between the federal government and the states, and in giving Congress broad new powers on top of those it already enjoyed to protect the right to vote. And so I think it's against the backdrop of this constitutional history, of the Elections Clause and the 15th Amendment, and all of the other provisions in the Constitution that recognize and protect the right to vote, that we should think about this question of voter suppression and what we can do and need to do to protect the right to vote, this vote that, again, is preservative of other basic civil and political rights. And so I want to start by thinking a little bit about what the problem is. In thinking about the problem of voter suppression, I think we need to think not just about the most obvious forms of voter suppression, but also other ways in which our democracy is undermined by the impingement of the right to vote. So perhaps the most obvious form of voter suppression are voter ID laws. So these are the laws which require prospective voters to present some form of identification before being allowed to vote. These laws obviously make it more difficult for individuals to vote, to exercise this fundamental right, and they often have a disproportionate effect on minority and lower income communities. Consider, for example, a law that was passed by the Texas legislature in 2011. This was a law that not only required voters to present specific identification at the polls, but also expressly precluded as permissible identification many forms of government-issued photo identification possessed in significant numbers by registered minority voters. Specifically, the law excluded federal, state, and local government employee photo IDs and student photo IDs from state colleges and universities, what you would think would be the quintessential form of identification you'd present at the polls if you had to present any, and in fact, forms of identification that had been acceptable in the past. It prohibited those forms of identification even as it allowed the use of concealed handgun permits. So a form of ID disproportionately held by white voters. Now this law, as egregious as it was fortunately ultimately struck down by the courts, but voter ID laws that impose various restrictions and requirements continue to exist in states throughout the country. So that's probably the most obvious form of voter suppression, but it exists and occurs in many forms. Another serious problem, voter purge laws. So just a couple of years ago, the Supreme Court heard a case about and upheld an Ohio law that allowed Ohio to purge registered voters from the voting rolls simply because they hadn't voted during a 6-year period and didn't respond to a card they got in the mail requesting them to confirm their eligibility. And this despite the existence of a federal law called the National Voter Registration Act, which prohibits state voter purge laws that remove individuals from the voting rolls because of a person's failure to vote. The idea is you can't be dropped from the rolls simply because you haven't exercised this right to vote. But the Supreme Court upheld this practice in a 5-4 decision, and because of that divided decision, these laws continue to exist throughout the country. A similar law in Georgia, because of it, 1.5 million voters were purged from that state's rolls between 2012 and 2016. On top of that, there are a host of other laws throughout the country and circumstances throughout the country that make it more difficult for people to vote. There are laws like the exact match law in Georgia that required registration forms to precisely match personal identification information in government databases. So a missing hyphen could make it more difficult for a person to vote. And there are issues like polling place closures and broken down voting machines, which we heard a lot about in the most recent election, and which often seem to be a problem, particularly in communities with high numbers of minority voters. On top of that, I want to flag 2 other issues that I think we're going to hear more about a little later this afternoon that are also serious problems when it comes to the right to vote. And the first is partisan gerrymandering. The Supreme Court this term is considering 2 cases involving partisan gerrymandering, the practice of drawing district lines to favor one political party over another. In one of these cases out of Maryland, the legislature drew the 6th congressional district to dilute the voting strength of Republican parties, seeking to flip that district from Republican to Democratic. In another case out of North Carolina, we saw the opposite. The legislature there drew a congressional district map that sought to maximize the election of Republican candidates by making sure that Republicans would wield political power far in excess of votes cast in the polls. And the map makers weren't quiet about the reasons why they did this. One of them said he drew the map the way he did because he thought electing Republicans was better than electing Democrats. So this sort of extreme partisan gerrymandering is wrong and it's unconstitutional, no matter who does it. The framers of our nation's charter established a system of government in which the people choose their elected representatives, not the other way around. Indeed, when they first drafted the Constitution, they wrote democratic principles into numerous aspects of the Constitution, and they buttressed our Constitution's commitment to popular sovereignty and to self-government through both the First and the 14th Amendment. Extreme partisan gerrymandering of the type that we see in both of those cases and in other cases that have been working their way through the courts subordinates adherents of a disfavored political party and degrades their right to vote, and just cannot be squared with the text and the history of the Constitution. And then finally, felon disenfranchisement. According to the Sentencing Project, 6.1 million Americans cannot vote because of a felony conviction. That number is pretty staggering when you step back and think about it. Over 6 million Americans are unable to vote because of a felony conviction, and millions of these have finished their sentence. They've served the time the criminal justice system said was required of them. And this is a practice that also hits minority communities particularly hard. Again, according to the Sentencing Project, 1 of 13 African Americans has lost their voting rights due to felon disenfranchisement, as compared to 1 in every 56 non-Black voters. So these are some of the problems. There are surely others. And I think the question then is, what do we do about it? How do we begin to address them? And so I want to wrap up by spending a few minutes just thinking about that question. So I'm a constitutional lawyer. Obviously, I think part of the solution is to fight back and to go to court to challenge these kind of practices that are at odds with our Constitution. My organization, the Constitutional Accountability Center, has filed amicus briefs in cases opposing voter ID laws, opposing partisan gerrymandering, opposing voter purges. And sometimes bad court decisions are going to require congressional responses. So for example, in a case called Shelby County v. Holder, a few years ago, the Supreme Court invalidated a key component of the Voting Rights Act. Section 5 of the Voting Rights Act required certain covered states and localities that had a history of discriminatory voting practices to get any changes to their voting practices pre-cleared by the Department of Justice or by a district court. And Section 4 provided the coverage formula, basically said which states and localities were subject to this pre-clearance requirement. In Shelby County, the court held that the coverage formula was unconstitutional because, in Chief Justice Roberts' words, it was based on decades-old data and eradicated practices. Now, I think the court was wrong in Shelby County, I think in part because it gave short shrift to the really radical transformation that the 15th Amendment worked in our system of government. But what matters for present purposes is that the court's decision left open the possibility that the Voting Rights Act could be restored with an updated coverage formula. And the elections since Shelby County have only highlighted, I think, how important it is that that happen. So that's one thing that Congress can do and has been talking about doing, is restoring the Voting Rights Act. Another thing that Congress could do is respond to that Supreme Court decision I mentioned earlier about the Ohio voter purge law. Congress could overrule that decision and make clear that practices that have the effect of disenfranchising people because they haven't voted in the past are unacceptable. And Congress could do other things as well. It could use the Elections Clause authority to set aside state voter ID laws. It could limit opportunities for partisan manipulation by prohibiting state officials from simultaneously running for office and running an election. And in addition to all that, I think it's important to think about proactive and affirmative steps that we can take to make it easier for people to exercise their right to vote. Congress, for example, could mandate automatic voter registration, providing that every US citizen is registered to vote in federal elections unless he or she affirmatively chooses to opt out. According to the Brennan Center, this simple response to voter suppression could add tens of millions of eligible voters to the rolls, in addition to saving money and in addition to improving the security of our elections. It really seems like a win all around. And automatic voter registration has a proven track record in some states and in countries abroad. At the very least, if we don't have automatic voter registration, we could have same-day voter registration. So someone who decides at the last minute that they want to vote can actually exercise this fundamental right. And we could have online registration in addition to paper registration to, again, just make it easier for people to exercise this fundamental right. Congress could also make Election Day a federal holiday. Again, making it easier for people to get to the polls and to vote. As we all know, getting to the polls can be difficult. It can be exceptionally difficult for folks who don't have flexibility in their work schedule, and particularly if they know they might face hours-long waits at the polls in order to be able to vote. It doesn't seem like that much to set aside a single day dedicated to Americans engaging in this incredibly important exercise. And there's other things we can do as well. Some states already have national voting, or some states already have national voting by mail. Again, to make it easier for people to vote, to make sure that no one has to face voter intimidation at the polls, to make sure that no one faces accessibility issues when they try to vote. These are just a few possibilities. There are surely others. But I think what's important, as I noted at the outset, is looking at the Constitution, looking at its text and its history and values. It's clear how important the right to vote is. And that makes clear how important it is that we do all we can to make sure that everyone can exercise this fundamental right. Thank you.
All right, so next up is Robert Tsai. He's a law professor at American University and also a prize-winning essayist in constitutional law and history. Robert was born in Taiwan, but he says that he's always considered America his home and that one of his proudest moments in life was the day he was sworn in as a US citizen. His research spans a wide range of topics within constitutional law, legal history, democratic theory, American political culture, social movements, criminal procedure, presidential leadership, radical constitutionalism. And you get a sense of the breadth of his knowledge when you look at what he's written about. He's covered topics like legal obstacles placed in the way of Black civil rights activists. He's written about President Franklin Roosevelt and freedom of religion. He wrote about the philosophy of John Brown and his followers, modern white supremacy and the militia movement, the Republic of New Africa's ideas about the Constitution, the historical treatment of migrants, and early socialism in America. He is a graduate of Yale Law School, and he worked under federal judges in New York and Boston. He worked under U.S. District Judge Denny Chin and U.S. Court of Appeals Judge Hugh H. Browns. And then he went on to serve several years as a civil rights lawyer in Georgia. He recently wrote a book called Practical Equality: Forging Justice in a Divided Nation. And his book is essentially a call to arms for us to do the hard work of equality. And it also explores the historical lessons for how we can make social progress in really tough times. So please come up to the lectern, Robert Tsai. Thank you.
Thanks so much for having me. It's a real pleasure to be here with you this afternoon. Thanks to Lincoln's Cottage. Thank you to Constitutional Sources for organizing the event. It's my job today to talk to you a little bit about the connection between the First Amendment and the right to vote. And I think it's especially fitting because we're sort of here today in this sense that, of course, the right to vote is an important aspect of President Lincoln's legacy, though he did not live long enough to see that realized. Also, we remember President Lincoln today as a wonderful exerciser of the First Amendment right to speech, one of the most eloquent presidents that we have ever had. Not only eloquent, but also in many ways pragmatic in his use of words. His use of words was involved both sort of decisions about aesthetics, but also, I think, in terms of practical politics. So it's in that spirit that I want to talk a little bit about the connections between the First Amendment and the right to vote with you today. So it turns out that the First Amendment has sort of deep connections with the right to vote. And we see it in a lot of different places. For example, we see it when the Supreme Court of the United States, as well as a number of other famous and prominent politicians, have talked about the right to free speech, for example, as important to sort of safeguard democracy. We see exactly the same thing being said about the right to vote. That the right to vote, as you've already heard, is preservative of all our other rights. And so it's funny that both of these rights, both the collective set of rights it contained in the First Amendment and the notion of the right to vote, are both described as sort of the two most essential things to preserving our democracy. So point one then is that both ideas are sort of moving in the same direction and sort of cornerstone ideas in our democracy. The other idea is that both are consistently described as fundamental rights. That is to say, they're rights that each of us as individuals enjoy against government. They're important ideas that both can be used to sort of prevent and indeed to sweep aside obstacles that are put in our way on the grounds that somehow these rules or laws are inhibiting some notion of democracy. I want to talk to you about two sort of separate areas where notions of the First Amendment can help us do some work in protecting the right to vote. And those two areas are first, the issue of partisan gerrymandering, and then the second, which has already been described briefly, which is the problem of felon disenfranchisement. Those are two really serious issues that we face today. Let me start first with the idea of partisan gerrymandering. What is this exactly? The idea of partisan gerrymandering is basically the idea that a particular party that is in power will try to entrench at times its own power, its own political influence by manipulating pre-existing districts. And the phrase you often hear here is cracking and packing, meaning they take an existing district and they'll break it up, and that's all of us, right? All of us who live in the district, and then they will reshape the district to either pack us all in, or many of us who might vote for the other party, typically speaking, into one district, and so that would make it very hard then to elect a civic leader of our own choosing. If we're sort of packed into in this one district, then in all the other districts, right, then the other party will have difficulty. The other idea, of course, then is that you could take an existing thing and you could spread out the members of the other party, people who tend to vote for the other party, so that no person from that party could possibly win a majority of the vote in those districts, and they'll always fall short of 50+1. And either way, the real problem here is that it dilutes our votes as individuals, right? It dilutes our ability to choose our leaders. And if you ever looked at some of these districts where you have extreme partisan gerrymandering, like the problem of racial gerrymandering, where the idea is to explicitly redraw districts to dilute the voting power of non-minority voters, you get these very misshapen districts. And in fact, in Philadelphia, I think it's probably like the 6th or the 7th district, is famously described as something like Goofy kicking Donald or something like this, because it looks like, it's so misshapen, it looks like one Disney figure kicking another Disney figure in the rear end. I kid you not, you'll have to check it out. And it's crazy, right, that this goes on. It raises questions of deep political unfairness. It entrenches the idea of the two-party system in a way that's deeply damaging to our notion of democracy, something that I think the framers themselves failed to contemplate, that we would have a system like this today. And well, what can you do about it? Well, there's a lot of things that can be done. For example, a lot of people have talked about creating independent commissions. In Pennsylvania, the Pennsylvania Supreme Court struck down their map recently, and an independent commission has been appointed to try to redraw this map. So notions of state constitutional law could be used there. That might be helpful. But I want to talk a little bit about another idea, which is that the First Amendment could possibly be a new idea, not so much new as an idea that's been floated but has not really been used in a way that has been implemented. And maybe we can all think about this possibility and find ways to use the First Amendment to really attack the problem of partisan gerrymandering. What's the idea here? The idea here is that we have a lot of experience with the First Amendment, and under First Amendment law, we tend to say things like this, that if there is a law or a particular state practice where someone is treating us differently or treating our vote, let's say, differently because of our ideologies, our political values, or even our affiliations, the political party that we tend to vote for, the party that we've registered with, the projected or expected party for whom we might cast our vote. If that's how the vote or state policies are based, then this is not just a problem of the franchise, but it's also a First Amendment problem, because we've often said that notions of free speech and the right of free association should not be impaired simply on the basis of disagreement with what we believe. Okay. Now, is there support for this? Yes. There is a case back in, I think it was about 2004 or so, a case called Viet versus Jubal in the Supreme Court of the United States, where the issue of partisan gerrymandering was raised very prominently, and the court ends up getting rid of the case, finding a technical reason to dismiss the case. However, Justice Kennedy, who was then on the court still, wrote a concurring opinion. And in that concurring opinion, he said that even more important than the right to vote, right, associated with the 15th Amendment, it might be that the First Amendment could help us out in ways that it hasn't before. And he sort of talked about all these ideas that I just described to you today. And he sort of threw it out there, right, without really doing anything with it. This set of ideas then has been thrown out there, and the most recent justice to take up this set of ideas is Justice Kagan. In a case called Gill versus Whitford that arose out of Wisconsin, she essentially takes up the mantle of Justice Kennedy and says that she thinks that the First Amendment has maybe more to say about the problem of partisan gerrymandering than the 15th Amendment and the right to vote generally, right? So here is one area where if the conditions show themselves, if we're good enough in terms of thinking about all the ways in which we can raise these arguments, then perhaps we can get the Supreme Court of the United States to think about it. It will turn on, say, for example, Justice Kavanaugh, how open he is to some set of arguments. I was actually fairly skeptical that he would be interested in wading into this area. Most of the justices have not wanted to get too involved here, but he was quite active actually in the oral argument in the two cases that Brianna just described, the one arising out of Maryland, the other one arising out of North Carolina. And it sounded as though he was, like his mentor, Justice Kennedy, looking for some sort of set of standards that could be useful here. Now, whether those are standards that are the traditional ones kind of coming out of the right to vote area, or whether they're of an empirical variety. So a lot of that hesitation here on the part of judges has been from not really seeing a workable standard that they could use to identify when we have just sort of run-of-the-mill partisan goofing around and the kind of extreme gerrymandering that really does have a major impact on each of our rights to vote. So that's the thing. Now, I was actually at a really interesting conference last week where a professor at the University of Chicago, Nicholas Stephanopoulos, has described a method that he's come up with in working with some very, very smart scientists. And they've come up with a model where they can show, by running various maps of all these states through this program, what a district, what a map would really look like if there was not A, racial gerrymandering, and then B, extreme partisan gerrymandering. That gives us a kind of a baseline for how legislators might behave in an ideal world. And then you could sort of compare that, right, with Goofy kicking Donald or whatever, just to show how crazy and awful gerrymandering can actually be. So I think that's very promising as an empirical matter. All right, but the other thing here, though, is that the First Amendment, as I've said before, whether it's in the Supreme Court of the United States or alternatively in places where state Supreme Courts, like the one in Pennsylvania, have been more willing to see that the problem of gerrymandering is a deeply corrosive problem that not only dilutes our right to vote, but also makes all of us very, very skeptical about American democracy today. All right, so that's one area. The other area I want to talk about is felon disenfranchisement, and you've already heard a little bit about it. And I wanted to talk a little bit about the problem in a deeper way, but also in a way that brings up the First Amendment as a way of possibly dealing with some of the problems. Brianna already told you that felon disenfranchisement is a serious problem. It's also a problem that has a long historical pedigree. As part of the ratification of the Reconstruction Amendments, they assumed that disenfranchising felons was probably a kind of power that most states were going to have. In other words, although some people worried that this power could be abused by the states, and there was some discussion of this, they really didn't spend enough time talking about it or thinking about it. And there's language, of course, in the Reconstruction Amendments that suggests that power exists. But nevertheless, I think that they could not have imagined just how abusive the practice really became. In the sort of post-Reconstruction period, extending into the progressive period, what we saw was that states where people who were in charge wanted to preserve white supremacy, that they expanded felon disenfranchisement. They were very explicit, including in Virginia, that that's what they were trying to do, but that if they were just clever enough and not mention race explicitly anywhere, they could get the job done this way. So for example, a very famous leader in Virginia, Democratic State Senator Carter Glass at the time, led a constitutional convention in 1902 to amend the Virginia state constitution. And part of this set of state constitutional changes dramatically expanded the kinds of crimes for which people could be disenfranchised. Previously, people lost their vote in Virginia only when they committed an infamous crime. But then after 1902, the new Constitution allowed the disenfranchisement of people who committed any felony, including bribery and petty larceny. And they specifically said during the debates that the point was to, quote, preserve the power of the dominant race. Some legislators objected, worried that it might actually mean that a few white voters would lose their vote. Is that a problem? And he essentially said, don't worry, we've seen how Alabama does this, and the numbers are quite good. He called it, quote, discrimination within the letter of the law. He promised, quote, it would not necessarily deprive a single white man of the ballot, but it will inevitably cut from the existing electorate 4/5 of the Negro voters. This plan of popular suffrage will eliminate the darky as a political factor in this state in less than 5 years. This is what he promised. The changes were made, and indeed, this is exactly what happened. All right. Let me tell you a little bit more about some of the inequalities, and then maybe talk a little bit about what the First Amendment could possibly do. The unequal effects on political participation through the expansion of felon disenfranchisement have been deeply corrosive. As Brianna mentioned before, at least until recently, there was about 6 million people who cannot vote, who may never get to vote again, simply for committing a single felony. 48 states, including the District of Columbia, strip a person of the right to vote while they're incarcerated. 35 states prevent parolees from voting. 31 states keep people who are on probation from voting. 4 states, at least until recently, deny the vote to all persons with felony convictions. And then here's an even worse problem, which is the haphazard quality in terms of the procedures for getting your vote back if you've lost it. Each state has its own separate procedure that allows certain offenders, but not others, to beg for your vote back. In some states, they have imposed waiting periods where the clocks don't start until parole or probation or the payment of all your fines and restitution has been completed. In Wyoming, you would have to wait 5 years before jumping through all the hoops before you could beg for your vote back. In Virginia, someone who has committed a drug felony would have to wait 7 years before asking for your vote back. This is an outrage, I think. This is deeply corrosive of our democracy. There are deep racial inequities as well. Let me talk a little bit about Florida, which until recently was perhaps the worst in the union. 1.4 million voters was disenfranchised until recently for committing a single felony. And you would be barred in Florida from voting forever. So you could beg for your vote back, and here's where it gets very interesting. You would have to go and you would have to ask for it back from the governor. And okay, so so someone challenged this last year in federal court, and if you read the records of the case, they're really fascinating, because what you saw basically individuals who would ask for the vote back, and they would basically try to signal to the governor's operatives, right? I'm going to vote for you, or I'm going to vote for the Republican Party, right? And then the people who signaled that way tended to see their vote restored. But if the governor's representatives felt that this was not someone who was likely to pull the lever for them, then they would not get their vote back. Now we see how it could become now a First Amendment problem, right? Because then what we're seeing is that the vote is being conditioned on an expectation of your ideology, right? Or perhaps your party affiliation. We've got lots and lots of cases that have said historically that you can't do this, right, in lots of other domains. So why not for this so-called most important right, preservative of all other rights, right? This is the idea here. Let me give you a few more examples from the book, which I think is really great. Yeah, so here's some more numbers. And there was other evidence that officials manipulated the reinstatement process for partisan gain. In 4 years under a Democratic governor, 154,000 citizens had their voting rights restored, while over a period of 7 years, a Republican administration only returned the vote to fewer than 3,000 voters. During one reinstatement hearing, the governor's representatives asked about an illegal vote. It looks like you might have illegally voted or voted when you weren't supposed to. This person was a white man asking for his vote back, and the man chuckled, "Oh, actually, I voted for you." And the governor granted his application. Interesting. At the same time, there were 5 other people asking for their vote back, all of whom were African American. They were also asked about possibly voting against the rules in some way. None of their applications were granted. We also found in the record that a Navy veteran who apparently had been a little bit outspoken during his hearing about the unfairness, get this, of felony disenfranchisement. He raised the issue during his hearing. This is kind of like, not right that we have to do this and beg for our vote back. I'm a veteran after all. He saw his application denied. A little bit too outspoken. Meanwhile, other people who keep their mouths shut about politically sensitive subjects apparently had a slightly better chance of getting their vote restored. Okay, well, I'm supposed to wrap up, so I just wanted to give you an example of how the First Amendment could do some good. You can see how these processes governing the right to vote can raise some of the basic underlying concerns we see in other areas raised about the First Amendment. And indeed, a federal judge did, for the first time, this is a very dramatic ruling, find that the process in Florida violated the First Amendment. And then a little while later, the people of the state got fed up. This was last fall. And some of you may have noticed, they enacted a dramatic ballot measure which amended the state constitution and re-enfranchised 1.4 million voters. And so hopefully that can be a positive way to end this, and that's something we can take with us today. So thank you very much.
All right, so we're about to hear from our last speaker, Elaine Weiss. She is a journalist and author who's based in Baltimore, and her feature writing has been recognized with prizes from the Society of Professional Journalists, and her byline has appeared in a number of national publications and on reports through National Public Radio. She is a MacDowell Colony Fellow, and Elaine received the Pushcart Prize Editor's Choice Award for her long-form writing. Her first book was called Fruits of Victory, The Woman's Land Army in the Great War, and it was excerpted in Smithsonian Magazine online, featured on C-SPAN. She now has a new book, which is called The Woman's Hour, The Great Fight to Win the Vote. It's received really wonderful reviews from the New York Times, the Wall Street Journal, Christian Science Monitor, NPR, and she's been traveling the country discussing the book and also talking about the women's suffrage movement. And a wonderful detail is that Steven Spielberg's production company, Amblin, has optioned her book recently for adaptation, and Hillary Rodham Clinton is set to be the executive producer. So join me in welcoming our last speaker, Elaine Weiss. Thank you.
Thank you so much. It's really a delight to be here at the Lincoln Cottage. Of course, President Lincoln was elected just 12 years after a certain meeting in upstate New York in Seneca Falls, which was the first, not the first time women started talking about getting the vote, certainly, but it's the first organized public expression in a women's rights convention where Elizabeth Cady Stanton stands up and says, we should demand the vote. And the rest of the participants, who were really very famous and brave reformers, say, hold on, that's going too far. We're going to be made ridiculous. They actually ask her to rescind the resolution. They don't want to have to vote on this. And it's a young man in the audience who had driven his buggy 50 miles from Rochester to attend the convention, who stands up and says, no, you must demand the vote. And it is 30-year-old Frederick Douglass who stands up and supports Elizabeth Stanton and convinces the other reluctant participants in the Seneca Falls meeting to endorse her call for the vote. It's a very interesting moment that it's just 12 years later that President Lincoln is elected, and the suffragists actually for decades and decades later will use a sort of bogus quotation from President Lincoln, which was actually a sentence he wrote in a letter in 1836 when he is running for re-election to the Illinois legislature, in which supposedly, according to their careful editing, it's sort of like book and movie reviews, you know, with the ellipses, and they get the sentence to sound like he would approve of women voting. I don't think that that is technically accurate, but they used it as in their advertisements all the same. But it's interesting because the leading suffragists of the time, Elizabeth Cady Stanton, Susan Anthony, Lucy Stone, are all abolitionists. They actually begin their careers as abolition workers way before they are suffrage workers. And the idea of women's suffrage comes out of the natural rights that are so important in the abolition campaign. So they are working for President Lincoln. They're actually pushing him a little farther than he wanted to go for the proclamation and also for the 13th Amendment. And they have organized themselves into something called the Women's National Loyal League. This is the first organized women's organization in our nation's history. and it is to support the idea of the president and Congress abolishing slavery and supporting the Union during the war. Now, what happens is these abolitionists / suffragists who are working so hard at this believe with their abolitionist brothers that come the end of the Civil War, this great, horrible war to end slavery, that they, along with black men, will be given the vote. Black men, black women, white women, universal suffrage. It's what Frederick Douglass was espousing for a long time. It's what the suffragists believed would happen. It did not happen. They were told by Congress and their aides, and reluctantly by Frederick Douglass, that it was not the woman's hour. And that's actually the title of my book. It was not the woman's hour. The women would have to wait. And the rationale that's used is that the nation could not handle two great reforms at once. Our attention span was not that good. And so they are bitterly, bitterly disappointed. The abolition coalition splits over this because Staunton and Anthony refused to support the 14th and 15th Reconstruction Amendments because women are not included. And Elizabeth Staunton says, if that word male is included as it is in the 14th Amendment, it shall take us a century to get it out, because the word male actually never appears in the Constitution before that. And she was almost right. It takes more than 50 years to get it out. But still, a little known fact, in 1866, so very soon after President Lincoln's assassination, Elizabeth Staunton runs for Congress from a district in Manhattan. And she, after the campaign and after on election night, you know, when you make your concession speech, she thanked her 11 male friends for voting for her. Because, in fact, you know, who would vote for a woman running for office? And this becomes an interesting aspect, because, in fact, there is no prohibition against women running for office. I don't believe there's any federal or state prohibitions for women running for office. But what's the use? Would men vote for a woman for an elected office? So that becomes the question. It's not that they are prohibited. It's who would possibly vote for them. So there's a wonderful database that it's fun to look at. It's called Her Hat Was in the Ring. And it compiles reports and documents that show that they now have 3,834 women who ran in 5,217 campaigns before 1920, before the 19th Amendment was ratified. And we do know that most of these elections were local, because the first degrees of suffrage that are given to women are at the local, usually school board elections are the entry point. And it's considered that's proper because this has to do with the education of children, so women know about that. And so that's the first entry point. And so a lot of these will be register of orphans, register of wills, and school board elections. But Victoria Woodhull runs for president in 1872. Belva Lockwood runs for president in 1884, and then again in 88 on something called the Equal Rights Party. So it's a minority party. It's symbolic. No one expects them to win. There's not a chance. But there's this sense that, okay, women can run. Let's see who might vote for them. So the first, in the first elections after Colorado grants women's suffrage, which is the first time, again, we heard about how the states have the power to control elections. This becomes a problem for women because many states have no intention of allowing women to vote. The first ones are in the West. There's historical discussion about why was the West so much more sympathetic to women voting, and some ideas are that it was the pioneer spirit and they'd forged the wilderness together. The other is that they needed women. There were only a few women in these states, and that's probably the overriding reason. And so as soon as Colorado men are the only voters who can decide whether women deserve to vote. As soon as that actually passes in 1893, in the next election cycle, in 1894, 3 women are elected to the Colorado state legislature, the first women elected to a state legislature. Women in Colorado, as they did in Wyoming, which was the very first state, came in as a territory that allowed women to vote. Congress tried to get them to stop that. Said, if you become a state, we don't do that here. And there's a famous, wonderful quote from the governor of Wyoming. He says, we would stay out of the Union 100 years if we couldn't bring our women in. So they become the first state that allow women. There's probably about 10 women in Wyoming, but they do allow it. And the Colorado women begin to vote for anti-corruption candidates. And this troubles the political parties, and they actually try to rescind women's suffrage because of this. So this brings us to one of the primary and most powerful arguments that we used by the suffragists themselves of why women should vote. Beyond justice, beyond we the people democracy. This is half of the nation that is being denied the vote. Beyond equal citizenship, beyond no taxation without representation. All of those arguments are used. But one of the prime and most powerful is that the nation needed women to participate in government because they were skilled and experienced civic housekeepers. They knew how to run a household, and they knew how to, you just like expand that idea and you can run a government. And this idea of civic housekeeping, using those domestic management skills into municipal management is a very powerful argument. Jane Addams uses it. Many of the suffragists use it. And they said women care about social welfare. They care about children. They care about how our society works. And they will help our government make more humane and responsible decisions. So the first victories of the progressive movement, in which women, again, before they most have the vote, are in those areas of enacting health and sanitation reform. So you see that women care about this. And so the suffragists are doing something very clever and a little counterintuitive. They're playing into, and at the same time, subverting two of the arguments that had long been used to keep women from voting. One of them is that women's elevated moral plane. Women were just too moral to have to deal in politics, that it would sully them, it would corrode their sense of spirituality. All of these are used all the time, that women, in fact, if they're allowed to vote, will be perverted by this exposure to evil politics. The other is that, and also women might be eligible for jury duty, which they were not. And this would expose them to the horrors of society. And this is used as another argument why women should not be allowed to vote. Now, the suffragists take this and say, well, if we have these higher moral values, we will bring that to government. We will make government cleaner. We will purify government. That is one of the most powerful arguments that's used by the suffragists. We will purify government. The anti-suffragists say, hell you will, and they're right, but that is, so, the suffragists say, we won't tolerate corruption in government. We won't support greed that harms the public. And Carrie Chapman Catt, who's one of the heroines of my book, who's the leader of the National American Women's Suffrage Association, the mainstream suffrage group, says, I believe that if women are allowed to vote, they will put an end to war. She's a pacifist, and she believes firmly that women would not allow wars to exist, that they would pressure their Congress, pressure their parliaments, and they would abolish war. She's sadly disappointed about that, but it becomes a very powerful moral argument. So the whole idea of a woman's vote, the suffragists say there is a woman's vote. It will be pure, it will be anti-corruption, maybe it will end war, but it will make your government better. Not just a fuller democracy, not just fulfilling the promise of the Declaration of Independence and the Constitution, but it will make us all better. So the whole idea of a women's vote becomes both a promise and a threat. Basically, it says, if and when women can vote, and it's coming, you know it is, you, Mr. Anti-Suffrage legislator, are going to be punished. We're going to go to the polls, and we're going to get you out. And that is used throughout the many referendum campaigns in all the states that take place between the 1880s and 1920. Now, before 1910, women could only vote in those 4 Western states. So this threat isn't really potent. But once, a few years later, in 1911, 1912, when California, Washington, Oregon give their women the vote by referendum, you begin to see there's bigger populations. And now these women can actually, it can mean something. And as we go into the larger states, by 1918, there are big electoral states, Illinois, Michigan, New York in 1917. Now the women say, I will work against those in Congress who've been keeping the 19th Amendment at bay for 40 years. It was introduced in 1878. It stood there for 40 years. It was ignored. It was sent back into committee. And they're saying, if you don't get this out, you're going to be out as soon as we can get the vote. And so beginning, again, they're threatening a bloc, a women's common interest bloc. And the question is, can they deliver this? So in 1919, beginning in 1919, when Congress, by the way, we're going to celebrate Congress's passage on June 4th of this year. I think there's going to be some celebrations in Washington. When that happens, an argument that it was being made quietly begins to get louder, and it's, should there be a women's party? Should there be a separate party where women decide who candidates should be? They field candidates. They propose and advocate for women-friendly, family-friendly legislation. And there's, again, a split in the movement about whether this should be done. Carrie Catt says, no. When we get the vote, you have to work in the political parties. You have to work in the existing parties. That's where the power is. You don't want to isolate yourself. You don't want to make yourself a second-class citizen by having no power. It'll be hard. They will try to keep you out. You have to keep pushing. Alice Paul and the Women's Party, the other wing, the more aggressive wing of the suffrage movement, says, wait a second, I think this Women's Party is a really good idea. I mean, they're called the National Women's Party, but it's really an advocacy organization until then. They actually hold a convention right after ratification to determine whether they should form a party. And they do begin to select and finance and campaign for women candidates. In 1920, while the ratification last battles are being played out, there's a woman, Anne Martin, who is actually a officer of the National Women's Party, who's running for the Senate from Nevada. And all the Women's Party women are kind of bouncing back and forth to spend time campaigning for her. She loses, but this idea that maybe this Women's Party can actually advocate. So I want to just, this whole idea of whether women vote as a bloc, can be depended upon as a bloc, begins to unravel as soon as ratification is complete. Because in that first election in 1920, again, just 10 weeks after ratification is completed, I have to give you the bad news that residents of Virginia never ratified. Residents of Maryland never ratified. In fact, did not ratify, both states did not actually ceremonially ratify until the 1950s. All for the same reason, they didn't want black women to vote. No mystery about that. But they actually, want to see whether women will vote as a bloc. And in that first election, 1920, it's clear they're not. Anti-suffrage senators in New York, in Pennsylvania, in Connecticut are all re-elected once women can vote. They vote for Warren Harding in a landslide, who, as you'll see in my book, is no great friend of suffrage. He's okay. His wife is pushing him. His mistress is pushing him. His many mistresses are pushing him. And so so in the election of 1920, there are 27 million women who are eligible to vote. Only about 10 million do. And Carrie Catt is asked, what happened? You fought for 72 years. What happened? And she said, voting is a learned exercise. It is not something that comes naturally. And most women have not learned to do this. They will learn. They will be educated. So she founds the League of Women Voters to educate both women and men to become on the issues, on the candidates. They're 100 years old now. They're still doing that. They're making democracy work. Alice Paul takes a different tack. They have a convention in 1921 to decide whether to become a political party. Their main benefactor, Alva Belmont, says, you better become a political party or I'm not going to fund you anymore. In fact, she refuses to vote. She has financed the suffrage movement for 40 years, and she refuses to vote until she can vote for a woman president. She does not live that long. And so what happens is women never vote in the numbers that the suffragists hope. There are lots of reasons for this. Part of it, it's legal now, but still your pastor may be against women voting. Your gardening club may be against women voting. It still was a brave thing to go out to your polling place in a conservative district and vote. And so it takes a long time. It's not till 1960 that women's participation equals that of men. And by 1980, it surpasses it, and we've been surpassing it ever since. On the other hand, is there a woman's vote? We hear about the pink wave. We hear about the gender gap. We know that in 2016, women voted in ways that seems counterintuitive in certain ways. But then we have to realize, why do we expect women to vote in a monolithic way any more than men would? Are there issues that would motivate this? In some specific elections there are. But are we being naive in thinking that women are going to vote in any specific way? But thus, do women lose power? So I can't answer that question for you. I hope to give you a little historical context. And I just want to end with a really beautiful note that Carrie Catt, once the 19th Amendment was secured, and you can read about how that happened and almost didn't in my book, but she writes a charge to the women of America. She goes home from Tennessee and she writes this: "The vote is the emblem of your equality, women of America, the guarantee of your liberty. That vote of yours has cost millions of dollars and the lives of thousands of women. Women have suffered agony of soul, which you never can comprehend, that you and your daughters might inherit political freedom. That vote has been costly. Prize it. The vote is a power, a weapon of offense and defense, a prayer. Use it intelligently, conscientiously, prayerfully. Progress is calling to you to make no pause. Act. Thanks.
All right, thank you so much, Elaine. And we have a bunch of great questions, more than we actually will end up with time to really address all of them. But I thought what I would do is just kind of quickly read through what many of you have put on here. And then if our speakers could just pay attention, and maybe you can each just take a minute or two and kind of tease out some final thoughts you'd like to give that start to address some of the questions that relate to what you said. All right, so first, thoughts on how to combat voter apathy and get Americans to actually go to the polls and vote. Another question, why are ex-felons not allowed to vote given the previous condition of servitude clause of the 15th Amendment? How should courts draw the line between baseline districting and extreme partisan examples? Since in general the powerful have only fully been inclined to moderate bad electoral behavior when facing consequences, what penalties should or could protect voting rights today? Doesn't gerrymandering, if unchecked, result in more extreme results due to the primary being the only meaningful election? The Oregon State Legislature is considering a law requiring Electoral College representatives to vote for the candidate with the highest popular vote. Would that likely be struck down? Please comment on the Electoral College and if it has become outdated in as much as 2 presidents in the 21st century received fewer votes than their opponents. Does the broad authority of Congress under the Elections Clause and the 15th Amendment imply that Congress, not the courts, should deal with districting issues? Then here, these aren't exactly questions, but just comments on campaign financing. Number 1, seems like Supreme Court interferes too much in campaign finance regulation. And this person also just notes that they disagree that parties are overall beneficial since they perpetuate their survival at the cost of the civic body. Someone here wrote on voter suppression, let's abolish Columbus Day and put in a national voting day. This one says, regarding mail-in ballots, weren't some trashed? How do we avoid that and make sure they are received and counted? This person says, any thoughts on when DC will gain 51st state status and voting rights? And then this one says, a presidential candidate recently mentioned abolishing the Electoral College. What are the experts' opinions on this, and is it even feasible? And then the final one I have up here is, would it be constitutional to require voting, like in Australia? Serving on a jury is a right, but it's also required. So a lot of great thoughts. I wish we had time to discuss all of them, but maybe, does anyone want to start addressing at least a few things you heard?
If I wouldn't mind, I'll take gerrymandering. I want to provide a little opposing view on these concerns about gerrymandering. The 2 justices that have served in modern times who know the most about how districts are actually drawn are actually Sandra Day O'Connor and Sam Alito. Sandra Day O'Connor was a state senator in Arizona, and she actually had a map that she drew rejected by the Justice Department in the 1970s, long before she became a judge and went on the bench. And Sam Alito, this is interesting, there's a 1982 or 1983 case called Karcher versus Daggett. It's a New Jersey redistricting case. Footnote 4 cites an affidavit from Sam Alito Sr. Sam Alito's dad was the staff level map drawer for the New Jersey legislature. And he's done an interview or 2 where he's talked about kind of how he learned about the redistricting process basically from watching his dad draw maps in their living room. So the two of them really have understood what legislators face better than anybody that's ever served on the court. And one of the things that Sandra Day O'Connor has pointed out, and Justice Alito's comments in the Whitford argument, the Rucho argument, the Benesek argument twice, have sort of fed on the same grounds. But essentially, Justice O'Connor says, look, gerrymandering is something the court should just stay out of because it's by its nature self-limiting. In other words, if you drew a map such that you dominated the legislature, but every single one of your party's districts had 52% of the vote, and there's a slight wave the other way, you could lose everything. And at the same time, if you drew all your districts so that your party's representatives got 65 or 70% of the district guaranteed, you're not going to have enough of your party to win a majority of the seats. So there's a self-limiting nature to gerrymandering that's getting lost in the popular press. And I think that Justice Alito is aware of it. Justice O'Connor was certainly aware of it. If you read her opinion in Ben versus Davis from the 1980s, she really talks about the self-limiting nature of gerrymandering and says, look, the court should just stay out of it because anything else really gets the courts into political decisions that she believes the court should stay out of. She writes, she talks about kind of if you accept this notion, then what classes become protected? In other words, should there be a certain percentage of gun owners in a legislature or a certain percentage of pro-life or pro-choice people in a legislature? What's the protected status of a political party? And she also goes on to point out that the Republican and Democratic parties in particular are not helpless, right? They always seem to find a way to help themselves. And so I just want to provide an opposing view on sort of the criticism of gerrymandering.
Okay. Do you want to make any last comments?
So many amazing questions. I'll just respond quickly to the one about whether the Elections Clause authority means that the court should actually stay out of partisan gerrymandering, in part because it actually ties into the comments Jason just made. And I think the answer is clearly no. If you go back to the framers' design for our system, they included the federal courts. They included Article 3, which creates and empowers the federal courts in our system, because the courts are supposed to be the final arbiter of what the law is, and they are supposed to serve as a check on unlawful action. And so what we have in the partisan gerrymandering cases is a legal question about whether extreme partisan gerrymandering violates the First Amendment, whether it violates the 14th Amendment, and it's quintessentially the role of the courts to adjudicate those kinds of questions. And so if the justices conclude, as I think they should, that there is an unconstitutional violation, it'd really be an abdication of their role not to step in. And then the only other concluding thought I'll share, which is that it was very interesting to hear Jason and Robert talking about these First Amendment issues, and to hear Robert's talk against the backdrop of Jason's discussion of campaign finance law and recent Supreme Court cases. I obviously disagree with Jason on a lot of that. I'll note that Citizens United, obviously we can't engage in a debate here about whether that decision was right or not. I'll note that 4 justices thought it was wrong and pointed out why they believed it was at odds with the Constitution and also years of existing Supreme Court precedent. But it'll be interesting to see what the court does in the partisan gerrymandering cases against the backdrop of these campaign finance decisions that embrace a really, really robust view of the First Amendment. Robert mentioned Justice Kavanaugh. It'll be interesting to see what he does. It'll also be interesting to see what Chief Justice John Roberts does. He has described himself as perhaps one of the most aggressive defenders of the First Amendment on the current court. And if you look back at the things that he has said in recent campaign finance cases, his own words help make clear why partisan gerrymandering is so problematic. So, just a couple of quick quotes. In McCutcheon, one of the cases that Jason discussed, the Chief Justice talked about how the First Amendment prevents the government from, quote, compromising the political responsiveness at the heart of the democratic process or allowing the government to favor some participants in that process over others. In that case, he also said that those who govern should be the last people who help decide who should govern. It's hard to imagine a statement that more precisely captures partisan gerrymandering. And so it'll be, again, really interesting to see what the court does this term with this incredibly important issue.
Any final?
I'm not going to talk about gerrymandering, but interesting question about the Electoral College. I mean, in recent years, we've had at least 2 people be elected president, right? Where they didn't win the popular vote. And so, again, we hear this question of whether we ought to do something about Electoral College. Obviously, to actually abolish it, we would need a constitutional amendment. But there are some interesting discussions going on in academia as well as in kind of the political sphere about whether there are certain kinds of things that can be done short of that would also be constitutional. One of the questions raised one of them, which is like perhaps each state or particular states could decide to allocate all of their electoral votes, right, to say the one who gets the popular vote in the state. And so that has been, I think, something that's very interesting. There's a question of whether that would actually fix the problem, because I was, again, at this really interesting symposium, and I like to share other people's ideas I hear that are really great. Although I should be hawking my own book, and I'm happy to sign my book for you personally. There's a guy named Ned Foley, who's a very smart guy who works in voting rights at Ohio State. He's working on a book, won't come out for a while. But he talks about the Electoral College a lot, and he talked about how the most recent time in which the Electoral College was discussed, that the real concern was getting that the electoral votes went to somebody within a state who actually got the majority of the votes, as in a 50+1. So that, in other words, if someone ended up with a plurality of the votes, like Donald Trump did, then that's the real problem, that all of the electoral votes in that state goes to that person. So a wrinkle on the idea that was in one of the cards would be to say instead that all of the electoral votes in, say, Oregon would go to the person who receives like a 50+1 of the popular vote, in which case if someone only gets a plurality, you would have to have a runoff. And then someone would have to clearly get 50+1 to get the electoral votes of that state. So that's something that Foley promotes as an alternative to other things like the Interstate Compact, which a bunch of states have tried to agree to give all their votes to the popular vote winner. But the problem is you might only get all the blue states to do that, right? And will that really deal with the problem? So in any event, those are some thoughts I would share. Thanks.
Are you good, Elaine? Any last comment you wanted to make? Okay. No, just on what you heard any of the questions raised.
Say that Maryland, which was so vociferously against the idea of women's suffrage in the 19th Amendment, that they actually brought suit that went to the Supreme Court. They said that the 19th Amendment was against the state constitution, which said only white men. And so they brought it, it went all the way to the Supreme Court, and it wasn't decided until 1922.
Just a quick question. Well, it's actually in Douglas Bachman's Slavery by Another Name.
Yes.
And it's about the condition of our country in the Deep South before we got the right to vote, as far as peonage, the mines, the turpentine factories, the slavery by another name,
Yes.
the plantations, it's up until the time when we got the right to vote. And in Douglas Blackman's book, basically says it wasn't until 1920 that that system started to break down, and people started to stand up and say, this really isn't right in those states. I mean, the North kind of turned their backs on it and said, you know, we've got other issues to deal with.
Right.
But how come that's never brought out?
That's very interesting. No, I've not seen that brought out. That women might have tempered that.
Right.
Yeah,
right.
that would be great. I don't know if that's yeah, no, that's wonderful. That's a really important point. But I don't think the women suffragists had to deal with gerrymandering.
All right, well, I think we're out of time, but I think of several, at least, of our speakers may hang around for a few minutes if you want to talk with them a bit more about your questions. And I know Erin's going to give just a few last remarks, but for my part, thank you all so much for being here. And it's been an honor to be part of it, so thanks so much.
The book signing with Robert Tsai and Elaine Weiss will take place downstairs. You can go ahead and proceed down there. I'm going to ask all the speakers to stay behind just for a few minutes so we could get a group photo real quick. But we will then all join you all downstairs. And one of the things that I was thinking about, thank you all so much for all of your remarks, is it was actually a quote that came up on a calendar I have on my desk that's a presidential quote a day, but it doesn't cite the quotes, which always drives me nuts. And the one for today, I was talking to my colleague about it, actually was in the back of my mind. Now, I can't tell you for sure whether or not this is a Lincoln quote because I didn't get a chance to look it up, but it was human action can be modified to some extent, but human nature cannot be changed. And that's something I kept thinking of throughout all of your talks, that, you know, in essence, we can try to move together forward for a more democratic society, but at the end of the day, you really can't legislate how people behave in a lot of ways. So thank you all so much again for joining us at President Lincoln's Cottage today, and thank you again to all of our speakers and to my colleague Callie Hawkins for putting together the program today. Thank you so much.